We'll get started anyway. My name is Jim Condos.
I know that.
Spencer. I am Vermont Secretary of State. Chris Winters is my deputy. And we started this, actually I started this about 4 years ago in 2011. Actually in 2010 when I first ran for office, I used transparency as really the basis of my campaign and took it one step further and got to the legislature in January of that year, proposed several changes which we'll talk about to improve transparency in government because I feel so strongly about it. And just to give you a little background, I served 18 years on my local city council that's South Burlington. I was chair of that council for last 8 years of that 18 years. I served 8 years in the state senate. I chaired Senate Education and Senate Government Operations. Government Operations is what deals with a lot of this language in the office of Secretary of State. So I really had a good background coming into this, and we'll just get started. Feel free to ask questions along the way. Turn it on. Why are we here? We're here for democracy, accountability, and openness. The public has a right to know. It comes directly from the Constitution. Vermont's open meeting and public records laws are some of our most important as they allow us direct access to the decisions that affect us all. And understanding these laws makes everyone a better citizen. That doesn't mean just citizens, it means also elected officials as well. In government, the ultimate boss is the public. The Vermont Constitution, Chapter 1, Article 6, says that all power being originally inherent in and consequently derived from the people, therefore all officers of government, whether legislative or executive, and you notice it doesn't say judicial, are their trustees and servants, and at all times in a legal way accountable to them. It's not, the judiciary is not there because the judiciary is essentially, they have their own rules that they follow. I'm on the tail end of a cold that I've had for, I thought it was 3 weeks, but Chris reminds me it's been about 4 or 5. This is just lingering and lingering. He wouldn't ride with me the first week. So, in government, the ultimate boss is the public. This is from the Declaration of Public Policy for, this is 1 VSA 311 is the declaration for open meeting law, and this one here is for the access to public records. And that's the basis of what we're going to do tonight. We're going to talk about the open meeting law, and we're going to talk about access to public records, two separate functions in government. So getting right into it, what is a meeting? It's a gathering of a quorum of the members of a public body for the purpose of discussing the business or for taking an action. Pretty simple statement. What is a meeting? What's a quorum? It's a majority of the entire public body. So if you have a 5-member select board, 3 members makes a quorum. If you have a 7-member, 4 makes a quorum. This is the joint authority clause, which actually says that if power is given to 3 or more, then you must have a majority of, you must have affirmative votes from a majority. So in this case, it'd be 3 or 4. I use as an example zoning board. I served on the zoning board in South Burlington many years ago. We had a 7-member board. 4 was a quorum, and whenever anybody came in before us to appeal a zoning variance or whatever, we always would tell them if only 4 or 5 of us were there, we would let them know that it was up to them, but they needed 4 votes, affirmative votes, in order for their appeal to win their appeal. So if they didn't feel comfortable with the 4 or 5 of us that were there, they could postpone to the next meeting when we might have 6 or 7, so they have a better chance. And on this one, let me just, I'll get to you. On this one of the things is, and we were just talking about this on school boards. School boards, you have to have a majority or a quorum in order to start your meeting. But once you do that, there is a special provision that allows school boards to operate on basically a majority vote of those that are present. But you have to start. So if you have a 7-member select board, you still have to, school board, you still have to have 4 members there in order to start your meeting and take any action. But you would be allowed to have 3 votes to move forward in that particular instance. Now, your question.
Thank you. If you have a committee of a public board and the committee meets, it is a quorum of the committee members and not the entire public board. Is that right?
Can you hold that for a second?
Oh, certainly.
Coming right up. What is a public body? Any board, council, or commission of the state, or one or more of its political subdivisions, municipalities, and any boards at the municipal level are political subdivisions. This one is more for the state, but it's any board, council, or commission of any agency, authority, or instrumentality of the state. And then this last one pertains to both of these, any committee of any of the foregoing boards, councils, or commissions. So you can have, and I'll just give you a quick example. The city of Burlington used to have, they have a 14-member, or at the time they had 14-member city council, and they used to set up 3-member subcommittees. And they didn't think they had to follow the open meeting law because they were only 3 members. There wasn't a quorum of the 14. Doesn't matter if the legislative body sanctions a committee of a certain number. That's the total membership of that body. So then you need a quorum of that body in order to move forward. Does that answer? What is discussing business or taking action? Discussing anything that the public body has the authority to oversee, and remember that open meeting laws apply regardless of where the quorum of the public body is gathered. You could have a 5-member select board, and all 5 members could meet at the coffee shop on Saturday morning to have coffee. As long as they're talking about the Boston Red Sox or Patriots, or anything not to do with what they oversee, what they have authority over, they're fine to sit there and talk. The minute they start talking, now here's the hard part, the minute you start talking about business that you oversee, now you've crossed the line. The only thing I'll say is this: nobody's watching, and it's hard for someone needs to be vigilant about it and say, hey, we can't talk about that going forward. So it's, and we've had occasions where when I was on city council, we'd have a barbecue with the city manager and our families, and 3 or 4 of us would get together and we'd start talking. As long as we were talking about sports, we were fine. But the minute we start talking about the highway budget or anything else, then you start to get into the wrong discussion. What is not a meeting? This is new language that was added last year. Essentially what it's saying is meetings shall not mean written correspondence or electronic communication, including email, telephone, or teleconferencing between the members of a public body for the purpose of scheduling a meeting, organizing an agenda, or distributing materials that need to be discussed at the meeting, provided that such written correspondence or such an electronic communication results in a written or recorded information that shall be available if the public asks for it. This came about because, frankly, government has a tough time keeping up with technology. Technology is changing so fast, and the statutes don't change that fast. So I know when I was chair of government operations, we were always trying to find that balance. We didn't talk about email directly. We would talk about electronic communications. We didn't talk about, because you didn't know what was going to come along, and that was back in 2004. Who would have known in 2004 that we're going to have Twitter or Facebook, text messaging? Hardly anybody would know that today. back then. Yes?
Is that saying that you can't call somebody and say, are you available for meeting Thursday night?
Mm-mm. That's saying you can.
Oh, okay.
This is, what this is saying is, it's, the meeting shall not mean a written correspondence or electronic communication, including email, telephone, or teleconferencing, if you're trying to schedule a meeting, if you're trying to organize an agenda, or you're trying to distribute materials. Where people can get themselves in trouble, if, say, the town manager sends an email out to all the members of the public body with attachments on it. Who knows, whatever the attachments are. There could be letters that, draft letters that they're going to discuss at the meeting. If someone hits reply all, you now have probably crossed into a meeting. So what I advise people, first of all, just take it as the meeting, as information coming to you. But if you're going to reply to it, reply. Don't reply all. Reply to the manager who sent it to you.
Even if it's just a scheduled meeting?
No, if you're doing this, you're fine.
Yeah, okay.
If you're doing any of this, but if you distribute material to discuss at a meeting and you start discussing it by email, we actually had a reporter call us because one town had a motion listed that was voted on, and here's what the motion said: to affirm what we discussed and decided by email. That was the motion. Didn't even give you an inkling as to what was in the motion, just that it was what we discussed by email. Hi. There's a handout right there. So there have always been some access to using things like teleconferencing, or I should say telephone conferencing, and I've actually participated in that kind of action. But now they've actually detailed it a little bit more. So this was updated in 2014. And you can meet by electronic means as long as requirements of the open meeting laws are met. That's specific. As long as the requirements of the open meeting laws are met, one or more members of a public body may attend a regular, special, or emergency meeting by electronic or other means without being physically present. If one or more members attend a meeting by electronic or other means, such members may fully participate, may vote to take an action, and any vote of the public body shall be taken by a roll call. Each member who attends the meeting without being physically present at a designated meeting location shall identify himself or herself when the meeting is convened, shall be able to hear the conduct of the meeting, and also be heard throughout the meeting. So if you're going to set it up, it's got to be available to anybody that's in the room to be able to listen, but the person on the other end of the line has to also be able to hear it. And the legislature actually took it even further and said if a quorum or more of the members of a public body attend a meeting without being physically present, so this is a quorum or more, so you have more people on the phone or whatever, Skype, you can do that as long as at least 24 hours prior to the meeting that the public body shall publicly announce the meeting, that a municipal public body shall also post notice of the meeting in or near the municipal clerk's office and at least 2 other designated public places, and that the public announcement and posted notice shall designate at least one physical location where a member of the press or a member of the public can come to listen to the meeting and participate. And there should be at least one member of either the public body, a staff member, or designee of the public body that shall be physically present at that location to ensure that everybody is able to hear it, everybody that wants to participate is able to participate. So who does the law not apply to? Doesn't apply to the judicial branch, doesn't apply to the Public Service Board, doesn't apply to quasi-judicial proceedings such as Development Review Board, BCA meetings with regards to tax abatements or tax assessments, clerical work or work assignments of staff, or routine day-to-day administrative matters. So the open meeting law does not apply to these folks. Yes?
Incorporated libraries versus municipal libraries, I understand that incorporated do not have to?
An incorporated library, if they are listed as a nonprofit, and for instance, if they technically an incorporated library is a corporation, and that is true. However, like VPT, Vermont Public Television, was an incorporated, a nonprofit, but they had funding that came, and it's not the amount of funding or who was funding, but who was funding it had a provision in their funding that said you must follow the open meeting law. And in this case, it was the Center for Public Broadcasting provided significant funds to Vermont Public Television. And when there was a little dust-up about a year ago, I think it was, as to whether they were properly following the open meeting law, they looked back. It was nothing that the state had anything to say about, but their funding source said you must follow the open meeting law. So it would depend really on if your funding source says you have to follow the open meeting law, but as an incorporated library, it's kind of considered separate from government. And you could be 100% funded by the town, but if they don't require you to follow the open meeting law, there's no requirement then.
That reference you made to the Board of Civil Authority has to do with when they're deliberating about a decision, but when it's a public hearing, they're subject to the open meeting. And any discussion about the...
You still have to start in an open meeting. You can go into deliberative session to discuss those pieces.
That's exempt. The deliberative
Right.
session. Right.
Spence, I'd also just clarify that when it's you're adjudicating some individual's rights, it's a meeting conducted in public, but not necessarily a public meeting, as in the public doesn't have a right to comment on that.
For instance, when you're doing a public hearing on someone's property, the public does not have a right. At that point, the BCA controls who's going to testify. So meetings and notices, the public must be given notice of the meetings. There are three types: regular, special, and emergency. Regular meeting, when a select board, and I'm going to use the select board a lot, when a select board, after post-election, they have their reorganization meeting. And they say, we're going to meet on the first and third Monday of every month at 7 p.m. at the town hall. So you got three factors. First and third Mondays, 7 p.m., town hall. If any one of those things change, then it becomes a special meeting. But as far as a regular meeting goes, they must adopt a resolution specifying the regular meeting schedule, and that's the notice that they're going to have a meeting for the rest of that year. They do have to post an agenda, and they do have to provide that agenda upon request. A special meeting, so if any one of those factors, those three factors change, the special meeting, then the time, place, and purpose of that special meeting must be publicly announced at least 24 hours ahead. Again, you must post an agenda. It requires a minimum of 3 public postings, and to each member of the public body. That's there to prevent a faction of a public body from not telling everybody that they're going to have a meeting because they want to pass something and they don't want any opposition to it. You got to be fair to everybody. And the news media if the news media has provided a written request for notification of special meetings, they must also be notified. We'll talk more about that in a minute. Emergency meetings are called to respond to unforeseen occurrences or conditions requiring immediate attention. It is not to call an emergency meeting, and the factors for this are they can be held without public announcement without posting of notices, without the 24-hour notice, provided some public notice is given as soon as possible before the meeting. We've had occasions where some towns have tried to call something an emergency meeting because they forgot to sign some papers on Monday night at the council meeting or the select board meeting. So they call an emergency meeting for Friday, but don't tell anybody. You can't do that. First of all, it's an unforeseen occurrence or condition requiring immediate attention. Really what it is, we're talking about an act of God. The dam is about to break. You need to meet and discuss what you're going to do. Town hall's on fire. Where are you going to meet? So what I always tell people is, think about it. You can call a special meeting on just 24 hours notice. It's not that difficult. In fact, my old town, just last year, I want to make sure everybody knows, I was not on the council after 2008. But actually 2007 was my last year. But last year, South Burlington called an emergency meeting. It was listed in the paper. So I called the town manager up and I said, you can't call an emergency meeting for that. They forgot to sign some papers or something. And he goes, well, it was an emergency. They had to be signed by that date. And I says, you could have called it as a special meeting. That's not an emergency meeting. That's a special meeting. And he argued with me for a minute, and then he contacted his attorney, and the attorney told him, yeah, he was right. So just keep thinking about what is the open meeting law about. It's about the public's right to know what's going on in their government. It's about transparency. And that's what we keep telling people. Go back to that. We've had people ask us, well, if we only had 2 members on the committee, can we avoid the open meeting law? And I said, are you doing it to try to avoid the law? Well, yeah. And I said, well, is that the right thing to do? So, agendas. This is new language. A meeting agenda shall be posted at least before, let me just back up for a second. The law said before last year that agendas had to be available prior to the start of the meeting to anybody that asked. There was no time limits on it, nothing. Now the legislature has decided to put some time limits on. A regular meeting the agenda should be posted 48 hours ahead, and a special meeting 24 hours ahead. And if a town has a website that they maintain or designate as their official website, it has to be posted there. And also that it has to be posted in or near the municipal office and at least 2 other designated locations. The meeting agenda shall be made available to any person prior to the meeting upon request. And then here's 2 new ones. These are best practices. This is what I think a lot of towns did anyway, but they now codified it in the statutes. Any addition or deletion from the agenda shall be made as the first act of business, and any other adjustment may be made during the meeting. Examples, example and a best practice. When I was on city council, going back to 1989, first item on our agenda was, are there any changes to the agenda? Always was the first item on our agenda. And if the town manager or somebody added something, if it required us to take an action, we would say that we were going to receive this as information purposes only tonight, and we would put it on our next agenda as an action. Because the public needs to be able to know that you're taking an action. And if you're just adding things at the beginning of the meeting, because there's no public there, this is a good time for us to pass this, that's not right. It's not proper. The other thing is this adjustment to the agenda. I also served on the Solid Waste District Board, and during the budget process, Solid Waste District reps would run around to all the towns, the municipalities within our county to explain the budget that had to be approved. And they might have 3 or 4 towns that they were doing on a given night. Well, we weren't exactly sure what time they would be in our meeting. They might be item number 4 on our agenda, but they might not show up till after item 7. So when we got to 4, if we didn't see them in the room, we would say we're going to move number 4 to after number 6, and then hope that they show up by then. If not, we'll move it further down. But that's just an adjustment. You're still, the warning still exists. You still have that item on your agenda. Yes?
I'm not sure if you actually said this or not, but for example, if on our school board agenda, we have both discussion items and action items, if an item is on the agenda as a discussion item, is the chair allowed to say this should have been an action item, we're going to change it to an action item?
I would say that that's not best practice.
Because this happened at our last.
I would say it's not best practice. The public, in a case like that, you have specific areas of your agenda where you identify discussion items and action items. So the public may reserve their time till it shows up on your action list. The other common thing that we've seen, in fact just recently, is some towns that put other business at the bottom of their agenda. And what they do is they add things, action items at the end because nobody's in the room, no member of the public. For instance, I'm talking about serious issues like buying 3 vehicles, and they don't want the public to know they're doing it. There's technically, I say technically nothing to stop you from doing it, but it's not best practice. And there's another provision that's coming up that actually plays into why it's not good practice. And there it is, the opportunity to be heard. This is the actual statement from the statute. It says the public shall be given a reasonable opportunity to express its opinion on matters being considered by the public body during the meeting, as long as order is maintained. The public has a right to participate. So if you're taking an item that says for discussion and now moving it to the action pile on that night, how does the public know to be able to have an opportunity to speak on it? So this statement is really a very, very important statement. And public comment shall be subject to reasonable rules established by the chair. Now let me give you a couple of examples. When I was served on the South Burlington City Council, we had a $10 million operating budget for the town. We might get 2 people to show up when we were discussing that budget. 2 people for a $10 million operating budget. The next week, we might have a discussion on our agenda to decide on a leash law ordinance to extend leash law to the bike path. This is true. 150 people showed up. 75 were for it, 75 were against it, and everybody, when I asked the question, who would like to speak tonight, everybody's arm went up. All right, so I'm chair of the committee, I'm chair of the council, and I look at it and I say, okay, we're going to set up 2 pads in the back of the room. Anybody that wants to speak, please go. We'll break for 10 minutes. Please go sign up that you want to speak, and we'll take them as they come and go through the meeting. And you're going to have 2 minutes to speak. And we'll time you and tell you when you have to stop. And we did. We gave everybody an opportunity. 150 people wanted to speak. We heard the same thing over and over again. And then when we got done, we said, okay, is there any other comments that we haven't heard? No hands went up. I said, in that case, I'm going to entertain a motion from the council to close the public's part of this meeting, and we're going to deliberate right here in front of you to discuss how we're going to take action on this. Almost within 30 seconds of us starting to talk, a hand goes up in the back of the room, and this guy yells out, "You're not listening to us." Now, we just spent 3 hours listening to them. But this is important. and this is one of the most important parts of the open meeting law, is the public has a right to participate. They have a right to express their opinion. So, minutes, public bodies shall take minutes, and those minutes shall cover all topics, motions that arise at the meeting and give a true indication of the business of the meeting. Doesn't mean verbatim. Doesn't mean you have to list everybody. When we had that meeting with 150 people that showed up on the leash law, we essentially said there was a lively discussion held about the ordinance to regulate leash law. Attached to the back of these minutes are the people who spoke, and it was pretty much evenly distributed. We didn't go through we get questions from time to time from citizens that call us up and they say, well, I spoke at the meeting, but they didn't write my name and what I said in the minutes. They don't have to. These minutes are not supposed to be verbatim. They're supposed to give a true indication of the business and shall cover all topics and motions. And here is what the law says the minutes have to have. They have to identify the members of the public body that are present, any other active participants in the meeting, any motions, proposals, resolutions made, offered, or considered, and the results of any votes. You could probably do your minutes on one page if you really wanted to. I'm not saying that's the right thing to do either, but I can tell you that 30-page minutes with basically a verbatim is not necessary and not required. Yes?
So I'm just recently started doing minutes for the DRB in Middlebury, and so we were trying to capture, because it's a public hearing and people are giving testimony, is that a little different?
Yes.
Okay.
DRBs are, when they're talking about a particular appeal before them, let me just say, part of your meeting is going to be considered open meeting, but then the part where you're actually dealing with the decision of what you're going to do, you can go into what's called a deliberative session.
Right, I understand that.
And there has to be a written decision that comes out of that.
Right, but what's discussed in there is not recorded.
That's true.
But what I meant was, when you're in your public hearing phase and people, you know, like neighbors or such, are giving testimony to why they agree or disagree with an applicant, we were trying to capture everyone that spoke, not necessarily exactly what they said, but that so-and-so spoke and gave testimony to these factors.
Yeah, I mean, you can put whatever you want in your minutes as long as these things are there. The public hearing is actually a little bit different, because if you are in the public hearing, that's a formal term, then there has to be a little bit more detail to what you hold in that.
Okay.
Usually that appears in your decision, generally. But there are other aspects at the DRB that are not. You still have to be in an open meeting to start with. And in order to go into a public hearing, you have to start in an open meeting.
Right.
And you have to have a motion that says we're going to go now into the public hearing on appeal number or whatever. And then there's a different part of it. So DRBs are always the one that people,
It's a little different.
it's a little bit different.
Okay.
When you say all members of the public body present, could you clarify that for me? Is that everybody that shows up at the meeting? Or
No.
the people who are on the actual
That's,
board?
they're talking about the public body, which is the board. So the members who show up, and in some cases, some towns will put down the following members were present, the following members were not present. And they list both.
So if you have 50 people show up at your meeting, you do not have to have the names of all those people?
It says active participants.
Right, so you do
If you're going to have 50 people show up and 50 people speak, then you would want to have a list that you would attach. And we used to, that's how we dealt with it, we would put a list of the people, actually, we would actually have a sign-in sheet for people coming into our meeting. And we would just attach that to our minutes so that we would have all of this information already.
Well, normally we don't get anybody at our school board meetings, but,
I understand, we didn't get very many people either. And we had $10 million budgets.
but I have the dubious honor of being clerk for several of the boards I'm on and committees. So the last,
You have to stop volunteering.
I totally agree with you completely. But at our last ACSU full board meeting, we had a lot of people who wanted to speak, or come. And so I tried to hand out a sign-up sheet, but when I got it back, I saw that there was no way everybody signed it. So that's not, I did note the people who spoke, so that I did have their names.
Well, our policy was we had the sign-up sheet for people coming into the meeting, but we also would take names, we would ask people to identify themselves before they spoke.
Right, and I do have.
And if they started, we would say, would you please identify yourself, to make sure we got it.
So as long as you have the names of the people who spoke, it's not necessary to have, if you missed people who.
No,
Were you sitting in the audience?
correct. It's all other active participants. Just being in the room is not being an active participant. It's if you're in the room and you're talking or speaking or whatever. Yes, ma'am.
Going ahead a little bit, minutes available in 5 days.
I was going to get to that.
All right. If the minutes are not approved until the next monthly meeting, do you put draft, which is what I did?
Yes. Except let me just clarify a little bit. There is nothing in the statutes and there's nothing in Robert's rules that talks about draft minutes or approved minutes. And all the law says is that the minutes shall cover all topics and motions that arise. So if you're not going to approve the minutes until later, well past the 5 days, you really could almost put this information on a piece of paper and say, here's my minutes. These are, and make sure you highlight them that they're draft minutes. And then when you do get approved minutes, just replace them.
Well, by then it's time for the next one.
Well, does your board keep their minutes ongoing, online? Or do you take them down after each time there's a new set?
We don't have them online. They're the fire district.
Oh, okay.
So we have a book of them. It goes back further. So when they're approved, I sign them, put them in the book.
That's the ones that you need. And minutes are to be kept forever. Minutes are the history of your board, the history of your town. So minutes are permanent records.
We've been encouraged to get our minutes. Some people on other boards are not as good at writing the minutes in other kind of manners. Now, we were told 5 business days, but you're saying 5 days.
Who said 5 business days?
I don't want to get anybody into trouble.
Okay. All right, well, here's the thing. There are places in the statutes that say business days, and then there are places where it says days. And the general wisdom is, if it says days, it's 5 calendar days. If it's, in this case, after 5 days from the date of the meeting. If it's, and this is something that the legislature is actually, there's a bill that's considering, and I'm not sure that they're even changing this piece, though.
There was some talk about it, but when it came out of the Senate, they were not changing it.
They left it, I think, but there was a discussion about, because VLCT, the Vermont League of Cities and Towns, was encouraging the legislature to make it 10 business days or 5 business days to at least get that extra few days in. That's not what it says. It says 5 days from the date of the meeting. So if you're on a Monday, start counting on Tuesday, and you got 5 days. And if the 5th day is on a Saturday or Sunday, that's what it says. Until the law changes, and they clarify where they stick the word business in, it's 5 days, calendar days.
I was just gonna point out, in the DRB, what we've been doing is making what we call mini minutes. And so they satisfy who was present, all the motions and the results, and that's it. Just satisfy those 4 bullets.
Right.
And we post those within the 5 days, and then about a week later, 7 or so days later, we have the full minutes, and then they just get replaced. So
That's a best practice.
one thing you could consider is doing that. Rather than trying to get your whole minutes done, just get your, what we call our mini minutes done and posted, and then go in and fill in and post those when you have them done. Okay. Just a suggestion.
What's the bill? That's what numbers on it? I know
Oh.
there was talk about changing this, so.
Chris will look it up.
Just a second, I would actually have that for you.
I think it passed the Senate and it's on its way to the House, but I don't think it got there yet, but I'm not sure.
Changing what?
Just looking at the open meeting law.
They were
generally.
They were looking at some minor changes to the open
Because
meeting.
I think the next slide, since you gave it to us, the thing about posting them on the website.
This is new language from last year.
I think that's the provision that has caused a lot of towns to abandon their websites.
Unfortunately, not a lot, a few.
So it seems awfully restrictive.
Well, let me say this. The open meeting law and the access to public records law were originally written in the 70s. And during all that time, it said 5 days. Minutes had to be available after 5 days. All that time. That's not new. The only thing that's new is posting them on the website. And like you said, there are ways to meet the requirement. We had one town that called me up. First of all, he accused me of doing it. I had nothing to do with this. I didn't even suggest it. But the legislature passed it, and he suggested that they're taking their website down, and it's a shame because people go there to find out their minutes, find out their agendas, find out when other meetings are being called. They pay their water bill, they pay their sewer bill online, and you're forcing us to take our system down so we don't have to comply. And I said, nobody's forcing you to do anything. This is not new language. It's only this that's new.
What's new is having to post it to a website.
Right.
Right, well the problem there is that a lot of towns have websites that don't fulfill these other functions that you're describing.
But
And so that means there's nobody available to update on that schedule. And that's why towns are
the problem that was also out there, and we experienced it doing these presentations, people would say to us, citizens would say to us, well, my town has a website, and it might be October, and the last set of minutes that they have is June. And my only response is, if a town really wants someone to use their website, they ought to keep it up to date, because the fastest way to lose people's attention is to make your website stale, is to not keep it up to date. Spence, I don't disagree with you. I don't disagree with you that towns have taken their systems down. I think it was short-sighted on their part. VLCT was advocating it actually at one point. And there was a woman who actually did a lot of the, I thought she was from Madison County. She did a lot of the, maybe southern Chittenden County, but she worked with a lot of towns on setting up websites. And she says, this is easy. I can train people to do this. It's not that hard to, click, and upload those minutes. I remember the days with emails when you used to try to upload a document. It would take 20 minutes for that document to load. And then when you hit send, it would take another 15 minutes for it to go. So I get it, I know, but I think it's incumbent upon the towns, because let's remember what the whole law is about. It's about the public's right to know. It's about the public's right to participate.
Yeah, but my point is that in many towns, a website was not a vehicle for conveying that kind of information. It's a vehicle for conveying what the population of the town is, what the annual events are, They didn't have any minutes on it. It wasn't a matter of being stale, it was a matter of not, and now they're required to put minutes on, and that means there has to be someone available to maintain it. And in Weybridge, for example, that's not the case. So
In a lot of towns, I don't know what Weybridge does, but I can tell you that a lot of towns, it's assigned to the town clerk to post stuff on the website. I get it, I know. Some of these towns are there's a lot of towns that don't have websites. There's a lot of towns that have very minimal websites. All I can tell you is that when we look at the law, when someone calls us, we have to tell them what the law says. The legislature set this up, that a website, if one exists, that the public body maintains or has designated as its official website, then the minutes have to be posted after 5 days. And the legislature chose the 5-day rule because that was what has been in existence for 30-plus years, that 5 days is that cutoff when minutes should be up there. And that's why I think some places they've gone to the mini minutes, just follow the law and then follow up with their approved minutes later on.
And I can tell you, Spence, I get a lot of these calls, and it really does make a difference for people. I had a call from a gentleman today for the town of Newport. I've got to find time to get down to the town clerk's office to get the minutes because they don't have a website and they don't put them out there. It was a burden on him because of his work schedule. He just wanted to know what was going on. So if you look back to the intent of the law, which is to get the public to know what's happening, and the public is accountable, and get people to actually participate and be informed about what's going on in their town, then we've got to find a way. But it's all built up. We don't have trained staff who can do that.
And just as a point, with what the legislature is doing, we still have the House to go through with this bill. The Senate heard the discussions about make it 5 business days, make it 7 business days, make it 10 business days, give us a little more time. But the legislature didn't want to confuse things by saying, okay, the minutes are still available, have to be made available after 5 days, but you can post them within 10 days or something. They didn't want to get into that dual deadline.
Do you get a lot of complaints about minutes not being available in 5 days?
Mm-hmm.
And what do you do?
We tell people to go back to their boards and ask them for the minutes. That the law did not change, the minutes have to be available after 5 days.
So I mean,
If someone wanted to challenge it, they could take it to court.
As a violation of the open meeting law. But we don't ever point people in that direction first. We say, just go speak to your board about it. We point people to the law and see what the law says. The bill number is F-114.
So what's it changing? Is that a curiosity? Do we
It's
know?
just a general look, and I think it came about because of the VLCT was looking for some changes to loosen up the enforcement provisions around the websites and not getting minutes up on websites if the town maintains them. The number of days to post minutes.
I don't know whether they changed anything, but
There were a few tweaks that came out of the Senate Government Operations. It didn't meet crossover, so it's in the Senate Rules Committee right now. So we'll see if it makes it over to the House this year.
Sometimes you can find them all.
I need to give up.
That's really not the point.
Oh, I know
The
sometimes
point
people are mistaken.
is that it's a new function for the website. And, that's the problem. Because if the town was not using the website as a way to convey timely information, but rather as a way to convey more static information, it's a new function. And that's why towns are taking them down. Because they don't, it's one thing to have somebody who updates the information about the town's population or when the annual picnic is or that on an occasional basis. It's quite a different thing to have a staff member who can really do that. So that's
I don't disagree with you, but the legislature didn't make those differentiations.
I get it.
And when someone asks us, well, what's the law say? I have to tell them this is what the law says.
And I think we're we're gonna reach out to VLCT again this year. I think it was the Snelling Center that did some work with towns, with some grant money, to get some towns without websites to have them, so that they're very easily maintained. And we gotta look at how to make that easier for the towns that don't have a website that can accommodate that.
Are there additional rights? Yes. Upon request, the agendas of regular and special meetings must be made available to the public or news media prior to the meeting. News agencies that wish to be notified of special meetings must provide a written request to the public body. That written request is good for the rest of that calendar year from that date forward. And if they make the request in December, it's good for the rest of that calendar year and good for the next calendar year. So anytime between January 1st and November 30th, it's good for that calendar year. And if you do it in the month of December, it's good for the rest of that calendar year and the next calendar year. Members of the public and news media have the right to attend meetings and to tape and videotape meetings so long as it is not done in a manner that disrupts. And the public has a right to know, and the news media have a right to know why a board is going into executive session. Let me go back to this one. Good example. We had a town in southern Vermont. A select board member got into a very loud argument with a member of the public. So loud and so obnoxious that the select board chair ordered the public access TV to turn his camera off because he didn't want to be embarrassed by the town people seeing this. Unfortunately, it was a fairly new young person who was on the camera, and he did what he's told. He shut the camera off. The next morning, press calls our office, wants to know whether that was legitimate or not, and we said no. I called the select board chair, I talked with him about it, and he realized, he said it was just the heat of the moment. I told the camera to shut off, and they did. As long as they don't disrupt the meeting, anyone is allowed to tape or videotape. Now, going into executive session. To go into executive session, you have to begin in an open meeting. You have to have a motion and a majority vote of the board on that motion, and you have to indicate the reason that you're going into executive session. The only permissible reasons for going in are set forth in 1 VSA 313. The next two slides will talk about those. A board may invite into executive session its attorney, administrative staff, and any persons that may be affected by what the discussion is about. No decision can be made in executive session except for one, and I'm not talking about going out of executive session. That's obvious. It's the only thing that you can actually take an action on in executive session is real estate purchase or lease options. Quasi-judicial decisions may be made in a deliberative session so long as there is a written decision that is a public record. So this one applies mainly to DRBs.
On the agenda, how specific do you have to be for the reasons about going into an executive session? And I'm thinking personnel issues versus disciplinary action against a staff member.
There's even an argument as to whether you can put executive session as an item on your agenda. We don't think that that's I don't think that's an issue. I think it's best if you say a potential executive session, or the board may go into executive session to discuss and put something there. When you're going to have the motion, first of all, you have to be in an open meeting. So and we had this happen too, where the regularly scheduled meeting is 7 p.m. on a Monday. That's town hall. And someone says, let's have our executive session at 6:30, and then we'll go into into the regular meeting at 7. And you've got to start as a regular meeting, as an open meeting. So if you're going to do that, if you want to go into executive session prior to your regular meeting, I would call it a special meeting that you're going to start at 6:30. You take the motion in an open meeting, and the vote, and you give the reason why you're going into executive session. We're going to talk a little bit about the reasons, but you have to give some kind of detail so that people know what it is you're talking about or going into session to talk about.
I just wonder how specific, you could say real estate matters versus.
You could say real estate matters, you could say the evaluation of a staff member, you could say, well, we'll get into it in a second here. So this is the first 5. After making a specific finding that premature general public knowledge would clearly place the public body or person involved at a substantial disadvantage for things like contracts, labor relation agreements, arbitration or mediation, grievances other than tax grievances, and new last year was pending or probable civil litigation or prosecution, and the last one was confidential attorney-client communications for the purpose of providing professional legal services to the public body. I want to just go back for 1 second. It says a board may go into executive session. So just because something is a contract doesn't mean you can go into executive session for it. Think about it. Do you have to? And I'll use as an example, if it's a labor contract, yes, you might want to go in to discuss a strategy or whatever the parameters that you're still working on for that labor contract. That's legitimate. But if you're talking about, let's say, the lease of a copy machine, do you think that the public is protected by not going into executive session for something like that? My argument would be I don't think so. So just because it says contracts doesn't mean necessarily that you have to go into executive session. In fact, none of these do you have to go in. You have to. The board has to make a decision, a finding, that premature general public knowledge would place the body at a disadvantage. We've actually heard this year that there are some towns, since they made some adjustments to all of these, and this one they've added some stuff that some towns are actually using a 2-motion process to go into executive session. One is they say, okay, we're going to make a specific finding that the premature general public knowledge, and they vote on that. Then they say, okay, now we're going to go into executive session to discuss. I think you can do it as 1 motion, but some towns have chosen to do it as 2 motions. The second one here is negotiating or securing real estate purchase or lease. That was new language, or lease. 30 years ago, there weren't lease options on property. The appointment, employment, or evaluation of a public officer or employee, provided that the public body shall make the final decision to hire or appoint the public officer or employee in an open meeting and explain the reasons for its final decision during that open meeting. So maybe I'll give 2 examples here. One, maybe you have to fill a position on, say, the Planning Commission. When you have 3 people that come in, you interview them in the public, and then you go into executive session to discuss the 3 individuals and which one fits best. You still can't make the appointment actually in executive session. You have to come back out into open session and identify the person that you're appointing to the position, and then also say why. And it could be as simple as we think they were a better fit. The fourth one here is a disciplinary or dismissal action against a public officer. But the public officer, if there's going to be formal charges brought, does have a right to a public hearing, an open public hearing. Fifth one, a clear and imminent peril to the public safety. In this case, let's say there's imminent flooding. The public body might want to go into executive session to discuss strategies around evacuations, temporary shelters, things like that. But then they can't actually take an action in executive session. They'd have to come out, but at least they could get their ducks in a row before they did. Here's 5 more. Discussion or consideration of records or documents that are exempt from the access to public records. So if you had a document that you wanted to discuss, but it might include personal information or medical information or social security numbers that are exempt by law, you can go in to discuss that. You can discuss academic records or suspension or discipline of students in executive session. And you can have, this one has to do with parole proceedings and the parole board. This one has to do with pharmaceutical rebates with Medicare and Medicaid. And then this is a new one that was added, the first one in 30 some odd years. It's municipal or school security or emergency response measures, the disclosure of which could jeopardize public safety. So it doesn't mean you can approve it in executive session, but you can go in and have your discussion about your emergency response measures. But when you come out, you would have to approve it in an open session, but you could call it a confidential document at that point. Yes?
Back to the very first one you talked about, you said some people do it in 2 motions. So are you saying that we have to say that we find a premature general knowledge would clearly place the public body involved in the substance?
I'm not an attorney, but most attorneys will tell you that you should be saying this. I will tell you that this is probably one of the most weakly followed parts of the open meeting law. People often will say, we're going in for personnel, and then they come out and they've taken an action, but they're not allowed to.
I mean, we would take an action outside of that, but we don't start out.
But you, whoops, I went too far. You do have a thing here about the appointment, or evaluation of a public officer or employee, and also one for disciplinary or dismissal action. That doesn't mean you can keep that quiet.
Can you elaborate on that?
Doesn't mean you. How do you take an action when you can't take an action in a meeting? How do you come out and take an action?
Well, for example, if we have an employee that the control superintendent wants to do something, when we come out of executive session, we generally say, we move to approve the recommendation made by the superintendent during executive session, or something to that effect.
And how does the public know what you did?
Well, they know we approved what he said, but I mean, you can't. It could be difficult to say, wouldn't it?
Well, let's think about this for a second. Let's say it's a teacher, all right, and a teacher is about to be fired for some reason. Does the public have a right to know that? If they're being fired?
Yes, I suppose they do.
And how would they know if you don't say? I'm playing devil's advocate here.
No, I understand that. So you're saying we should come out of executive session and say we approve firing the personnel person,
What I really say is you should consult with your attorney, the board's attorney. There could be some sensitive information that can't get put out to the public. I don't know. Every case has to be looked at in its own.
Is the distinction the action versus the reason? In other words, you might say you approve the firing of XYZ employee, and you don't have to say because he or she did this and that.
This one doesn't say anything about why you did it.
Right, that's what I'm saying.
This one does. If you're evaluating or assigning, appointing, employing, or evaluating a public officer, it says clearly that you shall make a final decision to hire or appoint in an open meeting and shall explain the reasons. It's really a good question for your attorney, your board's attorney. Even on a general sense.
Chances are, if you're making a decision in executive session to fire an employee, you're not going to come out and announce it. It has to be done in a certain way, so it's not to cause disruption.
And
the employee will know it that way.
Well, right, and I'm thinking even like sometimes we have student discipline issues, and that would be awkward to come out of executive session and.
that's one of the reasons why you can go into executive session, is to talk about student discipline. And students also have other protections that are involved in the exemptions from public access of records. So all those things have to be weighed in. That's why I would hope that someone's asking their attorney how to do this best. I'm not an attorney. He is, but I'm not. You could just go through these things with your attorney and find out what they say.
So if you hold an executive or deliberative session, do you have to have an action when you come out of it?
Mm-mm.
Okay. So you can discuss something.
Well, let me clarify. You said executive or deliberative. Those are two different things.
Oh, yeah, they are.
Okay, deliberative, if you can take an action in a deliberative session as long as there is a written decision. That's why generally a development review board will decide what they're going to do in deliberative session pending essentially the signatures of the board to approve the final written decision. So they don't take an action that night formally in the public. But when at some point in time there's going to be a written decision that's part of the record.
So when we've had deliberative sessions, we make it out of deliberative session and then make a motion and vote on it.
Okay, you can do that.
But I guess that was to Lorraine's point. If they're making a decision about firing an employee during an executive session, they don't have to come out of that meeting and take an action. They can wait until they've
Consulted their attorney. They could wait until the attorney drafts the firing motion or the firing paperwork, and then it'll be approved at a later time. But you can't take that action in an executive session. As I said, there's only one thing you can do. The law is clear. An executive session. That's real estate purchase or lease options. Everything else has to be done in the open meeting in some way or fashion. It's not what everybody wants to hear, but it's...
Well, no, I understand what you're saying, but when you say action has to be taken, the action has to be more...
No, I'm not saying there has to be an action.
No, but if we have made a decision in executive session, when we come out, we can't be generic about how we phrase it, you're saying, because...
Yes. We had another time we had another town that said, this was literally in their minutes, that this is to affirm the decision we made in executive session. That was the motion.
Well, and we literally do something very similar a lot of times. I mean, not exactly like that, but you know.
Well, I'm saying exactly what they said.
Right.
All right? There was nothing. Here's the point. 2 years from now, the public's going through the minutes. What was this? What did they do here? How do they know, if they have no detail at all, what that action was? That's the point. The public has a right to know. Let me give you, actually, not so much this part, but this had to do with minutes. South Burlington City Manager was hired the same week that I won my first election to City Council, 1989, May of '89. I did not run for re-election after 2007. I served 6 terms, 6 3-year terms. he stayed for, I think it was 2 more years, so he was there for 20 years or 21 years, I forget exactly. He retired. The new town manager and the new select board or city council, completely new, all new people, could not find anything when they looked back through the minutes, because Chuck would call them up and say, hey, I'm supposed to get this retirement benefit. And they said, well, there's nothing in the minutes or anywhere that we know that this action was taken. Because we did a poor job, and I'm pointing the finger right here, we did a poor job in assigning, making sure that the minutes were correct. But 4 of the 5 city councilors showed up on the night that the council was going to make their decision, and all 4 of us said, we raised our hands and said, we took that action, we went into executive session, we came out, and we don't know why it's not in the minutes. Similar, I think, we might not sign our minutes for a month. And a month later, who remembers everything that occurred? What we used to do when we went into executive session, if we came out of executive session, the town manager would turn the agenda over and write any motions that we took with the vote totals, and then add it to the minutes when he got the copy from the clerk. He apparently forgot to put his own benefits that we had passed into the minutes. So eventually the town board decided to sue, they denied him his request for his benefits. He filed lawsuit. I remember his attorney called me up and said, so I want to understand exactly what you think happened. And I remember saying, this thing is never going to see the light of day in court, because we have 4 out of the 5 of us, and I think the 5th one would have agreed as well, but he was out of state at the time. We had 4 out of the 5 city councilors that said we took that action. We don't know why it didn't show up in the minutes. We can only surmise why, but we took that action. And consequently, the insurance company for the town agreed that they were probably going to lose that case, so they basically gave him all of his benefits. That's why minutes are important. That's why they need to be clear. And that's why when you come out of executive session, your minutes have to mean something. The action has to mean something. So open meetings, meetings held without respect to the details of the law may be illegal. Courts may regard any action taken in those meetings as voidable. Essentially, if you didn't follow the process and someone challenges and the court agrees that that board did not follow the process, they could void any action under that process. Most likely what the court will do is say, go back and do it over and do it right. Illegal meetings offend our notions of openness, accountability, and democracy. In Vermont, the people do rule, sometimes directly, sometimes indirectly, but always with the benefit of public scrutiny. There are penalties. These were strengthened, but also these 2 words or 3 words, who knowingly and intentionally violates the provisions of the chapter. So a person who is a member of a body and a person who knowingly and intentionally violates the provisions on behalf of or behest of a public body, and then any other person who participates in the wrongful exclusion of any person from any meeting could be found guilty of a misdemeanor. And this makes it a very high bar to have to get by. So, I mean, there really has to be a clear intent. So that's the penalty phase. Oops, wrong way. There we go. There are 2 pages here that you have in your packet about pre-enforcement process. I don't get into this usually because you have it in front of you. It's really time-consuming and boring. But it's basically the do-over portion that allows a community or a board to do over. If someone challenges them and they think, okay, maybe this person is right, we should have done this differently, you can go back and do it the right way. And you have certain timelines, like there's a 7 business days, a 14 calendar days, and another 14 calendar days, at which point there are certain times that you have to be able to do something, otherwise it will go to court, it will go to the judge, and the judge will make the decision. So that's the open meeting section. Usually this takes, as it did here, takes the longest. The next section is about public records. But is there any more open meeting questions? Oh, that's okay. It's good to see you, Spence.
Thanks for coming.
If not, we'll get right into the access to public records. This can go quick. What is a public record? Any written or recorded information, regardless of its form or characteristics, produced or acquired in the course of a public agency business. So that basically is a very generic statement, but it's basically whether it's on paper, on a disc, on a tape, whatever way it is, it's considered a public record. Remember, records are not limited to paper, and all government records are considered public records, but that some of those public records are exempt from disclosure to the public. So there are exemptions that are listed throughout the statutes that talk about that. The public records policy, we already talked a little bit about this, but it allows, provides for free and open examination of records consistent with the Constitution, and it is in the public's interest to enable any person to review and criticize those decisions, even though it may cause inconvenience or embarrassment. But then down here, there's also this piece that talks about shall be liberally construed to implement the policy, and the burden of proof falls to the public agency to sustain its action. So if John Q. Public walks in and says, I want these documents, and the town says, no, you can't have them, John Q. Public does not have to prove that they were public records. The town that denied has to prove that they were right to deny. That's the assumption that's being made. And this part about shall be liberally construed also shows up in a Supreme Court decision. When can the public inspect and copy? This is a state agency. Any person may inspect or copy any public record by a state agency, 9 a.m. to noon, 1 p.m. to 4, on any day other than Saturday, Sunday, or a legal holiday. For public agencies of municipalities and other subdivisions, the right to inspect and copy applies during customary business hours. And that's mainly to recognize the fact that some towns, the town hall might only be open 1 or 2 days a week.
I have a question. The town often, 2 or 3 times a year, gets a request by these data mining firms that wants the whole grand list and stuff like that.
I know the individual you're talking about. There is one particular guy.
We've sort of sidestepped that, okay? Sometimes ignored, sometimes come down and it's $1 a page per copy. You know, what is the right thing to do? I mean,
They're entitled, and this person has contacted us. Basically, he says, like, he wants the voter checklist, but he wants all the information that we're not giving him. And we tell him there is no other information we're not giving you except for birth dates and driver's license numbers and things like that, social security numbers. And you can't have that, that's exempt from public. But he'll sit there and he'll still yell at us because he's found that if he is belligerent enough and persistent enough, that sometimes people will give him what he wants just to make him go away. You have to be vigilant. He's still entitled to the information that he wants. And you can charge. You can't charge $1 a page.
oh,
We'll get into that in a minute. We have the fees coming up,
Okay,
but you have to actually charge the actual cost. There are some provisions where a town can make their own list up that might differ slightly, but I don't think anybody would get $1 a page. That would be pretty hefty. What we've gone to and started doing is, with this particular individual, when he makes the request, is we'll set up, and I forget what it's, I should find out, but it's like a separate web page that's password protected, and we'll tell him the information you're looking for, because it's voluminous amounts of information, and he will ask us, he will say to us that he wants us to send it to him by email. Well, we tried to send it, but it was so much information that the email wouldn't accept it. It was too big a file. So we decided, okay, we're going to set up this system where we have a separate web page that he can go to, and I forget what it's, there's actually a name for it, but it's password protected, and in the particular instance, it took us several hours, so we charge him for the time, and we tell him, once we receive the money, we'll give you the password and you can have access. Now, he doesn't like that, so he doesn't do it. But we've complied. He also, this particular individual, threatened to, I got sworn in on a Thursday at 2 o'clock. The next morning at 9 o'clock, he called my office, got me on the phone, and within 1 minute, threatened to sue me if I didn't give him everything he wanted. And I told him to step in line. You get what you're entitled to, but nothing more. You can ask, but you can't deny someone for whatever reason that he wants the information. If someone says, I want the floor plans for the city hall or the schools, you can't deny them unless it's got an exemption that allows you to deny them. Now, schools might be a little different, but this is from a Supreme Court decision against the city of Burlington. Public records exemptions. The agency is required to produce records for inspection or copying unless the record is exempt from public inspection or copying. There is a list that was begun back in the 70s that shows up here in 317. That list is about 41, 42 exemptions long, but we have found an additional 220 that are scattered throughout the statutes, and we've actually made a list. There's a URL in the packet for you that you can actually go to this particular page. Well, we'll get to it in a second here. Examples of commonly exempt information is personal documents on individuals, medical information, Social Security, investigations, trade secrets, tax records. And it's a good idea for each government agency that collects records to know which exemptions pertain to them. The burden of proof, this is, again, this is a Supreme Court decision. It represents a strong policy favoring access to public records, and exceptions to that general policy, again, are in 317. We construe these exceptions strictly against the custodians of the records and will resolve any doubts in favor of disclosure. So if it's even close, the court is saying that if it comes to them, they're going to fall to the side of being open and giving it to the public. And again, it continues with that the agency seeking to avoid the disclosure is the one that has the burden of proof, not the person that's requesting it. This is the right to know database I was telling you about. This is the URL on our website. You can actually search exemptions by agency, exemption type, or through a keyword. It's at our state archives, and we have something like 240, 250 exemptions that we've been able to identify. We suspect there are more. And that's the first time in state government that this has appeared. So I'm very pleased that we were able to do that. Complying with a request, all public agencies are obligated to comply, and unless otherwise allowed by law, agencies must accept the record request in any manner or format. So they can call you on the phone and say, this is the list of records I want. They can send you an email, they can write you a letter, they can come in and verbally tell you. It doesn't matter how. However, an agency may require a request to be made in writing if staff time will contribute to the cost of complying, and specifically if it's going to be more than 30 minutes. Upon receiving a record request, the custodian of the record must promptly produce the record for inspection.
Again,
Yep.
produce the record for inspection, like the tax book, okay? So we have the tax book that's public, everybody can come and look at it, and then they count it. We get requests to email that to them, okay? And to date, so far, we've said, come in and take a look at the tax book, and anytime you want. These are the hours the town clerk is open.
There are some national, I don't know what they're called, data miners.
Yeah.
That are looking to get all that information from everybody.
Yeah.
You don't have to provide it by email.
Okay.
You can provide it on a disk or on paper, but paper is going to really cost and probably be very time consuming. But we're going to get into the actual cost of this in a second.
Okay.
If the record is in active use or in storage and not available at the time of the request, the custodian of the record must certify in writing that the records are not currently available and establish a day and time within 1 week that the record will become available. This is most often occurs in the town clerk's office. They might be on their computer doing tax payments and stuff like that, where for them to have to shut down the program, get out in order to find something else for them could be problematic. They don't have to, but they have to say in writing to the person that requested that, okay, I'll get you the information you're looking for, but it's going to be next Monday at 8 o'clock in the morning or something. You just have to identify when it's available. If the record does no longer exist, the record custodian must also certify in writing that it no longer exists. If the record custodian believes that the record is exempt, then the custodian of the record must certify in writing what record is exempt and the basis for that denial. In other words, which exemption applies. Unless there are unusual circumstances, a certification must be made within 3 business days of receiving the request. So if someone requests something from you, essentially you've got 3 days to deny them. If it's a simple request, you really shouldn't be taking 3 days to give it to them. You should give it to them as quickly as you can. But you do have 3 days. If you're going to deny, you do have up to 3 days to deny. If the denial of access is appealed and the agency head determines that the record custodian must comply, then the record must be made available promptly. Whoops. Unusual circumstances means the agency cannot comply within the time limits outlined, and if an agency needs an extension, it must submit a written notification to the individual making the request and specify the reasons and the date when a determination, this is to make the determination, will be made. Extensions may not exceed 10 business days and are only allowed for the following reasons: the need to search for and collect the requested records from field facilities or other establishments. Example of that might be someone comes in, they want, from our office, they want some corporate records that we hold. They're public information. But we don't have them all at our office. Some of them are sent out to at certain points in their lifespan, they're sent out to the archives. So we'd have to go out to the archives to find them. So in a town, it might be the town clerk's vault isn't big enough to keep all the records. They might keep some of their records in the public works garage, in the attic or something, you know, whatever. It allows you time to be able to find those records that they're looking for. It also gives you the need to search for, collect, and appropriately examine voluminous amounts of. So if someone asks you for lots of information, you can also ask for 10 business days. Actually, you don't have to ask for it. You have to tell them you're going to need some more time. And then the need to consult with another agency. This basically is we see it at state government more than at the local government, but at state government, it might be the two agencies are basically contribute to a report or a record, and so they're both considered owners of that record. So sometimes they might come to one agency and say, I want this record, and that agency says, well, I've got to confer with the other agency or with the Attorney General's office to determine whether we can give that to you or not. If access is denied, and that denial is appealed to the agency head has 5 business days to make a written determination, and the written determination shall include the statutory basis for denial, a brief statement of reasons, and the supporting facts for that denial. If the head of an agency upholds the denial, in whole or in part, the agency shall also notify the person making the request that there are provisions for judicial review of that determination under Section 319. If the head of the agency reverses the denial, the record shall be made available promptly. It used to be challenged by requesters, but now the legislature has made a change that you are allowed to discuss narrowing the request. So if someone says they want a tremendous amount of information, you're now allowed to ask them basically, what exactly are you looking for? You've asked for this, and is what you want this? You know, try to... What? Oh. My big fingers. So, in responding to a request, a public agency shall consult with the person making the request in order to clarify or to obtain additional information that will assist in responding to the request and when authorized in facilitating production of the request. In unusual circumstances, as that term is defined, a public agency, this is again, right out of the law. In unusual circumstances, as that term is defined, a public agency may request that a person seeking a voluminous amount of separate and distinct records narrow the scope to make it easier to do the records, meet the records request. This was also new. It was always best practice, but didn't always happen. And essentially what this says is, if you have a document, in the old days, a lot of agencies, government agencies, whatever, if there was one piece of information that was exempt from disclosure, they would say the whole document was exempt. Best practice is that you go in and redact the exempt information, and now it's mandated by statute. So a public agency shall not withhold any record in its entirety on the basis that it contains some exempt content. Instead, the agency shall redact the information it considers to be exempt. And I think the easiest one to explain is if you have a document that has is about somebody and it has their social security number, and I don't want to say the old days, but in previous times, they might exempt that. They might say that whole record is exempt. Now you have to redact any information such as social security number, but still give the document. This was also a new provision in 2011. Under the old law, judges had the option to make the state or municipality pay attorneys and other legal costs to the party who successfully challenged but such imposition of fees against agencies were more the exception. In fact, we only know of about 5 or 6 times over 30 years where a judge actually awarded attorney's fees. So it helped to create a culture in government in Vermont of deny. In other words, because the worst thing that was going to happen was the judge is just going to say, okay, give up that record. And you go, okay, and you give up the record. Now, there's a penalty that goes along with it, because under the new law, judges are required, except in very narrow exceptions, to make an agency pay for the attorney and other legal costs to the successful challenge. So now if a citizen challenges, or a press, challenges an agency who refused to give up information, and the court rules that the person requesting the information was correct, they should have gotten the information, they can now have their attorney's fees paid for. It's actually changed the culture. It was basically one word, from may to shall. Do you have to gather new information to create new documents in order to respond? No. A requester, and this is from a Supreme Court decision, a requester cannot obligate the government to create a record which is not already in existence or required by law. Agencies may charge to create documents that don't yet exist. So if someone comes up to you and let's say you have a particular IT format, the computer format that you use, but the other person can't read it, you're only required to give it to them in the format in which you as a government has the document. And if they say, well, no, I want it as an Excel spreadsheet, then you have the obligation to say, no, we'll give it to you the way we have it, this is it. Or you can also, so if you decide that it doesn't exist the way they want it, you may charge, if you agree to change it to an Excel spreadsheet, you can charge for your time, and you can provide, as long as you provide that estimate in writing, and you can require payment ahead of time. And we actually had a case where someone asked us for some information, and it actually made sense. We didn't have a way to report the information that he was looking for. So we had our software developer actually create that report for us, but we didn't charge him for it because it was now something that we could do going forward for anybody. So I think you have to kind of take that into account. I have a hard time, I tell my staff, look, if it's less than $25, I'm not going to charge someone for that. Just give it to them. It's the spirit of the law. Fees, this is the fees part. Agencies may only charge and collect from the public the actual cost of providing the copy, including mailing and transmission. And we actually, I'll get into this a little more, but staff time for complying with the record may not be charged or collected unless the staff time exceeds 30 minutes, the agency agrees to create a new record, or the agency agrees to provide the record in a non-standard format, and the staff time then will involve more than 30 minutes. If you're going to do this, you have to provide an estimate to the person, and you can request that money be paid up front before you undertake the work to do that. There is a uniform schedule of public records charges for state agencies. Actually, unfortunately, I think we should change this, Chris. We have a uniform schedule. That's supposed to be a link, but it doesn't really work as a link when it's on printed form. There is a link to the page that we have for the uniform schedule. This is what state government runs, and actually municipal governments are supposed to follow it unless they have their own schedule that they've approved. And it's supposed to be the cost, the actual cost. So, for instance, on our standardized fees, a single-sided copy is 5 cents, a double-sided copy is 9 cents. I think a CD is like 87 cents or 86 cents. Labor, the most expensive would be a senior administrator at 57 cents per minute. It has different levels that you can charge. So there are things, but we do have to update this. We'll have to work with the administration, factor in all the utility. Does it say? Yeah, utility charges directly associated with the copying. So copy machine. You can factor in lease agreements that maintain it, those kinds of things. Any cost that actually is involved in providing that. Are there penalties? If any person who willfully destroys, gives away, sells, discards, or damages a public record without authority shall be fined not at least $50 and not more than $1,000. And that's the end. And I did it before 8 o'clock. How about that? So, any questions? If not, I hope this has been helpful.
So how do emails, like, are emails between, you know, the town clerk and the chairman of the select board, for instance, are those public record?
Depends on what the topic is.
Okay.
We start from the presumption that they are. That they are
So
public
if you
record.
want to know what they've been emailing about, can you go in and request copies of their emails?
That's where you start to get to the point where you actually say to people, what is it you're looking for? So,
But if you tell them what you're looking for, then you give them a hint of what you're looking for so that they can delete them before they can see them.
well, yeah, but if you delete them, then you're liable if they can. And trust me, what's on this computer, they can get it out.
I know, it's just,
But you've asked a good question about emails, and let me just clarify a little bit. I guess that they're telling us we have to go out that door. Emails, because some people will tell us, well, I use my personal email, that way I don't have to keep it as a public record. It doesn't matter whether it's personal email or not. It's what is the subject of that email, what is the topic, what is inside that email, that's what matters. So, and when I was on city council in the 90s, email was just really starting to proliferate, and what we used to do was any member of the board would, if we got an email from a constituent and we were responding to them, we would copy the city manager so it would fall into his email as well, which was the city's email. Today, a lot of towns are actually providing email addresses to their elected officials so that it better enables them to meet requests for public records. Like, for instance, when the city of Burlington, I think it was in the last year, had a request, I think it was, I don't know if it was the NRA or people associated with, that requested every email that mentioned the word guns. And they wanted it from your personal email, from your text messages. They wanted it, any email, any communication regarding guns. The city had a tough time following up with 14 city councilors and going to each individual email account and trying to pull that information out. So shortly after that, I believe the city of Burlington did go to a city email for each of theirs. I know South Burlington did, and other towns have done that, where they have assigned an email address to every elected official solely for the purpose of being able to better manage the records, which makes a lot of sense.
So if you, for instance, wanted to see emails, you would be better off, you know, I'm just thinking hypothetically, but, you know, you want to see between the town manager and the select board chair regarding, you know, I don't know, the new town office building. You would have to make a request for emails regarding that subject. So what if you just wanted to know what they've been emailing about? Can you just say, I want to see your emails between them for the last year?
I suppose you could, and then they'd have to make a determination of what, I mean, you would be allowed, or the elected officials would be allowed to say, go through their emails and say, okay, this email is personal, or this email has nothing to do with city business.
Or it might fall into one of these.
Or it might fall under an exemption. But that's what becomes the problem when you have all these different emails. And that's why, like, the city of Burlington now has a computer program where they can actually pick the email time period and say, okay, give me every email that references guns, or every email that references guns and something else.
You don't know what's been going on for emails, so how can you,
You have to look at them individually.
right, but, so you want to know what, what conversations are being had by email, but you don't know what to ask for because you haven't seen them, so
That's correct.
how do you make the request?
Well, anybody that's really making a request knows what they're looking for, usually, and they're going to ask for specific information. And that's why that one slide I showed, you can actually talk to the person and try to narrow the request down to something that you understand that help. And this is all in the interest of helping to comply with the law.
Right. Okay.
Any other questions? I hope this has been helpful.
Thank you for taking the time.
Yeah, thank you for the time.